what the disability carrier will do is basically doing a 1-2 punch. And what do I mean by that? They will have their in-house liar for hire doctor or nurse review your claim and determine what, in fact, they think your restrictions and limitations are. In fact, what they're trying to do is to argue that you can do at least a sedentary job, which is a job sitting down 6 out of 8 hours, basically lifting between 10 and 20 pounds with standing at about 2 hours. Because their position is if you can do a sedentary job, you can do any kind of work, and therefore no benefits are due and owing. Now, they'll get to the vocational conclusions by using their captive in-house vocational evaluator. And many times this in-house vocational evaluator will make some significant mistakes. They'll misinterpret your work history based on the jobs that you've had in the past, and they'll arrive at the conclusion that you have what's called transferable skills. These are skills that you will have learned by virtue of these occupations that you could potentially take those skills to other occupations, even in a sedentary capacity. They'll misinterpret the education history to arrive at the conclusion that you can perform other occupations, and they will misapply the plan definition or policy definition of other occupation. So what we have here is an improper transferable skills analysis, a misapprehension of the occupational duties that you still might be capable of doing based on the transferable skills, and then a failure to consider the impact of both exertional and non-exertional impairment that will reduce a person's ability to do even sedentary work. And then, of course, they'll top this off, like a cherry on top of the cake, by failing to perform, if they have to, a proper labor market survey to document that the jobs or occupations exist and that they exist at such a wage that benefits would not be payable. And you can see that any one or a combination of these reasons can be attacked as part of any kind of appeal. So now that I have set the framework for this, I do want to talk about the different exertion levels defined by the U.S. Department of Labor. Now, the different non-exertional restrictions that have to be developed to prove that you can't perform your own or any occupation is really crucial. And I will talk about that in a minute. But one of the ways that I go about addressing, in fact, what the correct functional restrictions and limitations is to use a Social Security disability residual functional capacity form. And the reason that I do that is that those forms ask the right questions about a person's restrictions and limitations. And as a Social Security attorney, I want that addressed specifically. I actually attach these to the APS forms in my long-term disability case. So I've got the carrier's APS form that doesn't ask the right questions, but then I also have the residual functional capacity form that does ask the right questions. Now, what are those different exertional levels as defined by the Department of Labor? And so the question here is going to be ultimately, can you perform the material and substantial duties of your own occupation, and then at the any occupation, based on whatever those restrictions and limitations are. Now, at the own occupation stage, the carrier or the plan is going to review the work history, determine what occupation you performed at the time you became disabled. Remember, you did not insure a job, you insured your occupation. And once the VEs determine the occupation, then the VE will use the Dictionary of Occupational Titles to determine the strength level of that occupation. And then, yes, next, using those restrictions and limitations assigned by their doctor, the VE will determine whether your post-disability exertional level matches between the exertional requirements of your own occupation and whatever your current restrictions and limitations are. If you've got the same post-disability exertional level that you did when you were doing your own occupation, your claim is going to be denied. Even if the exertional level is different, the carriers or plans will still play games with this. They'll try to whittle things away or add things, if you will, so that the restrictions and limitations may be less, but the skills that are required your client that you have will transfer to whatever this new occupation is. So a bit confusing. So let me give you an example. Let's say you're a systems engineer. Under the DOT, that's defined as a sedentary occupation. Now, if the restrictions and limitations that the carrier is using are sedentary in nature, the VE is going to say that you can do your past occupation as a systems engineer without regard to non-exertional impairments like the need to change positions, maybe issues with bilateral manual dexterity, issues with concentration or pace. They will ignore those types of non-exertional restrictions and look solely on the exertional restrictions limitations. Now, if there's a dispute about the post-disability restrictions and there's no match, then my position is that you can't do a full range of your past work, which is sedentary in nature, and therefore you're entitled to your benefits. And that analysis holds true at the any occupation stage. So what is this full range of work? You have to be capable of doing a full or a wide range of work at the exertional level assigned preferably by your physician, or even better, the carrier's physician. So you have to be capable of substantially all of the activities of your own occupation at that exertional level. I use in my appeals Social Security Regulations 83-10 and 83-11, and I use them to argue that notwithstanding what the disability carrier's physician's opinion is, that you still can't do the full range of the occupational duties, and therefore you're entitled to your benefits. So let's talk again about the exertional levels, particularly when we get to the any occupation stage, because the game there, as I said, is the ability to do sedentary work. If, let's say, for example, you did a job working as the manager at a Lowe's, you would be doing heavy physical work. And let's say post disability, your restrictions and limitations are now perhaps light. What the VE is going to be doing is looking at what the occupation requirements were of a manager at Lowe's to see whether or not the skill level would transfer at the light level. And I'm going to discuss transferable skills in later videos. But in my example of the Lowe's manager, that occupation is defined as heavy work. One of the things that you need to understand and become familiar with is the Social Security regulations and the Department of Labor definition of things, because I use these in combination to attack the carrier's determination as to what the exertional level is and whether or not the client's capable of performing their own occupation, or at the any occupation stage, any other occupation. So let's start out with some definitions. The definition of heavy work is defined as lifting no more than 100 pounds at a time with frequent lifting and carrying of objects weighing up to 50 pounds. If you can do heavy work, then you can do medium work, light work, and sedentary work. What's the definition of medium work? Well, look at Social Security Regulation 83-10, which defines medium work as lifting no more than 50 pounds at a time with frequent lifting or carrying of objects weighing up to 25 pounds. A full range of medium work requires standing or walking for a total of 6 out of an 8-hour day in order to meet the requirement of frequent lifting or carrying of objects. How about the use of arms and hands in medium work? Now, medium work requires the ability to grasp, hold, and turn objects. And a lot of impairment keys, in my view, is the ability to do gross and fine motor movements, because that can erode a person's ability to even less than sedentary. So I'm always looking at my clients' medical records to see whether or not they have any cervical issues, radiculopathy down their arms, carpal tunnel, tingling, numbness. They might have issues, for example, with MS that will cause problems with coordination and dexterity. It really doesn't matter the nature of the disease. It's the symptoms that we can establish that impact manual dexterity. Now, there is obviously considerable lifting in the full range of medium work, and that also requires frequent bending and stooping. So As a practical matter, most medium work requires being on your feet most of the time, and the ability to frequently lift or carry objects up to 25 pounds and being on one's feet all day can really be more critical than being able to lift up to 50 pounds. So in the case of our Lowe's manager, they would potentially be unable to do the work as performed at heavy and probably couldn't do the work as performed at the medium level. So that's the game here, is to basically develop the exertional restrictions and non-exertional restrictions that would preclude you from doing the full range of work. Let me give you another example. Let's say you're a tank truck driver and you can lift up to 25 pounds. That occupation is defined as medium, but if you can't stand more than 30 minutes at a time or the dock or while making a delivery, and then have to take a 10-minute break, that standing and break limitation would preclude you from performing the material and substantial duties of your occupation as a truck driver. Now, how about light work? The definition of light work is found in Social Security Regulation 83-10, and it's lifting no more than 20 pounds at a time with frequent lifting or carrying of objects weighing up to 10 pounds. Now, there is obviously a great deal of walking and standing. A job does also require sitting most of the time, but that can also require pushing and pulling with your arms, hands, legs, or using foot controls. And that can really increase the exertional level. By the way, frequent means occurring from 1/3 to 2/3 of the time during the workday. Now, the full range of light work requires standing or walking off and on for a total of 6 out of 8 hours a day, and sitting will occur intermittently during the remaining time. So let me give you an example. Let's say you are a client relations manager. You travel as part of your occupation, attending trade shows. Obviously, you're carrying presentation material. You are probably putting up a booth, taking it down. But while you're at the event, you're sitting. You could be sitting, you could be standing, you could be lifting up to 20 pounds. And, if you are then lifting up 20 pounds of promotional material, standing at a booth at least 6 hours, sitting intermittently, then perhaps your occupation would be defined as light. But again, we want to work with non-exertional impairments, such as the need to alternate sitting and standing, the need for breaks, issues with bilateral manual dexterity, pace, and concentration, to erode the full range of that. Well, let's talk about sedentary work, because this is, in my view, at least at the any occupation stage, the game. Social Security Regulation 83-10 defines sedentary work as lifting no more than 20 pounds at a time, occasionally lifting or carrying articles like files, ledgers, or small tools. There is a certain amount of walking and standing necessary even in a sedentary job, but a job is still classified as sedentary if the walking and standing are required only occasionally, and the other sedentary criteria are met. Now, there's no significant stooping. Most sedentary jobs require good use of hands and fingers on a repetitive basis, bilateral manual dexterity. And occasional means occurring very little or up to 1/3 of the time. Now, since being on one's feet is required occasionally, the periods of standing and walking should total no more than 2 hours in an 8-hour day. And sitting generally should total 6 hours in an 8-hour workday. Let me give you an example here. Let's say that you're a surgical nurse. That can be classified as medium work under the DOT. You've had back surgery with a fusion, and allegedly you can sit up to 6 hours a day and lift 10 pounds. Now, obviously, your own occupation benefits will be paid, but the game's going to be played here at the any occupation stage. The carrier or the plan's VE will probably opine that you could perform other occupational duties like a peer review nurse. However, let's say you've got carpal tunnel that limits your bilateral manual dexterity and the use of the computer to occasionally, then you no longer meet the definition of sedentary work. If you've got to get up and move around every 30 to 45 minutes by changing positions, and that's going to put you off task, that will also erode the ability to do sedentary work. So they came here, I think, ultimately at the any occupation stage is less than a full range of sedentary work. And so we want to reduce that by looking at a combination of exertional and non-exertional impairments. Each impairment whittles away at that range of sedentary work. And that's a game we have to play and a game we need to win. Now, I've indicated that one of the ways to do that is with a need to alternate sitting and standing. If you look at Social Security Regulations 83-12 and 96-9, you will see Social Security guidance on these points. Now, again, this is alternating sitting and standing that can't be accommodated by scheduled breaks and lunch breaks. Again, eroding the occupational base. Now, the extent of the erosion will depend on the frequency of the need to alternate sitting and standing and the length of time that this is going to happen. There are a number of times that's going to happen. Most of the time, the peer review doctors will say, well, you can sit 6 or you can alternate in such a fashion that they would still meet the productivity requirements. Again, what the game here is for them to say, look, you can do some sort of a managerial position that's sedentary in nature that lets you sit or stand as needed, and you can meet the pace and production requirements. That's the first game. The second game is that they're going to say that you've got transferable skills to other occupations. And part of that example was in the nurse, because the nurse had skills that could transfer to peer review, which meant looking at medical records and determining whatever the carrier or employer wanted to be determined. So those are the two games. And the way we go about attacking these is not only to ultimately, if need be, get a functional capacity evaluation and have the treating doctor sign off on it, but we also want to develop the non-exertional restrictions to prove that you can't perform your own occupation or any occupation. Exertional abilities involve sitting, standing, walking, lifting, carrying, pushing, and pulling. Everything else is considered non-exertional. Again, I use Social Security rulings 83-12, 83-14, 85-15, 96-4P, 96-8P, and 96.9P to attack the non-exertional impairment issue. So you might want to go and read those. Now, as a general principle, there are 5 different types of non-exertional limitations, and I want to develop each of these as I can in my claims. First is postural restrictions, including the need to alternate sitting and standing, the need to elevate legs, difficulty turning one's head, balance problems, difficulty with bending, stooping, or squatting. So, for example, if you have POTS, you have trouble turning your head side to side. If you have balance issues, you may have problems with coordination as you're moving side to side. So we want to develop the postural issues. Same way if you've got a herniated disc in your back, you may have to get up and move around. Because of the pain in your legs, you may need to elevate your leg. So we want to develop those as appropriate. Now, the second category is manipulative restrictions. That includes difficulty with reaching, grasping, handling, and fingering above your head, in front of you, to the side, and behind you. We want to develop any manipulative restriction. Environmental restrictions can include difficulty working around fumes, tolerating noise, heights, humidity, or temperature, and an inability to be around dangerous machinery. Mental restrictions can include difficulties relating with others, difficulty understanding, remembering, carrying out simple instructions, an inability to maintain concentration, or poor stress tolerance. Now, this can be a bit of a trap if there is a mental nervous policy limitation, which generally limits benefits to just 2 years if you are having psychological or psychiatric problems. The applicability of that mental nervous policy limitation will depend on the policy language. Sometimes there is what I call the Monty Python version, which is if the psychological problems contribute ever so small, then benefits are just limited to 2 years. We want to be careful about that. Now, other non-exertional impairments are sensory restrictions involving speaking, hearing, feeling, or seeing, visual difficulties. Now, carriers and plans rarely ever identify or consider non-exertional limitations, much less the combination of exertional and non-exertional restrictions and limitations. In my view, this is great grounds to attack a wrongful denial or termination of benefits. Let me give you an example. Let's say you're a software engineer and you've had neck surgery, you have difficulty moving your head side to side, you have difficulty with your arms, particularly with tingling and numbness that radiates into both hands. Software engineer is classified under the DOT as sedentary. Now, carriers will generally say that you can return to that sedentary work since there are no sitting restrictions and deny the claim. However, my argument is since you have difficulty moving your head side to side, you have postural limitations that would impact the ability to turn your head side to side and up and down. You also have issues with bilateral manual dexterity. There are issues with manipulative restrictions that would impact not only the ability to do data entry, but potentially impact their production and pace. So we want the treating physician to address both the exertional and non-exertional limitations. Remember, I started this out by saying that I use Social Security residual functional capacity forms. Well, I do that because those Social Security residual functional capacity forms address both the exertional and non-exertional impairments, while the APS form just doesn't do that. Now, we've got to tie this all together because the vocational evaluator should address the DOT classification, for example, in this software engineer situation, address the physical and cognitive requirements of the occupation, and address both using the carrier's liar for hire restrictions and limitations and the treating physician's restrictions. We want the VE to address why, from a vocational standpoint, you can't perform the material and substantial duties of your own occupation. And the same thing goes in an any occupation claim. You can see developing the exertional and non-exertional impairments are key. We want to get to less than a full range of sedentary employment, combining both the exertional and non-exertional impairments. And then we want to tie it up in a big bow, if you will, with your vocational evaluator's opinion. Now, you've got to be giving the doctor a really good history of your symptoms and the impact the symptoms have on your ability to function. So it's really crucial that you are giving a very good interval history because at the end of the day, everyone is in part relying on your subjective report of your restrictions and limitations, which are hopefully corroborated by the functional capacity evaluation or corroborated by the residual functional capacity forms. Again, you can see how using Social Security regulations and forms can help win your claim and overcome a wrongful claims denial. Got it? Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claims Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claims Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.